or I stand.
No problem. Got it. Okay, so let's see who all, so far we have you and our trustee court reporter,
How are you?
Bill. So what we'll do, folks, given the nature of this, is we'll wait till 11:35, and if the plaintiff Thomas doesn't join us, then we'll dismiss this case.
Your Honor, I always am very careful when I'm dealing with someone who is not represented by counsel. I can tell you that there were emails, communications with Mr. Thomas's brother on Friday that I believe Bill was copied on, where I provided him with the discovery. And I know that he got it because he confirmed that he received it. I've checked my email somewhat religiously since then, looking for some email from him that said that here it is, Ms. Koenig, here is the material that you asked for, or asking for other questions. And I haven't seen anything from him. I mean, I know that I sent it to him. I know that he responded that he received it and he would respond to what we had requested. But I haven't seen anything other than that email.
Thank you. We'll give Mr. Thomas 2 more minutes to join us, and if he doesn't, then that tells me he's not interested in pursuing this case.
You know, Your Honor, I think it's, as I said, I'm always very careful when I'm dealing with someone who is acting as their own lawyer. And I try to dot all the T's and cross all the I's, so to speak. And, you know, I in this instance, I sent him a letter. I followed it up with a formal discovery request because the letter got nowhere, so to speak. Then I even waited longer than I normally would when someone hasn't responded, and then sent the Rule 6.4 letter again. And even after the deadline that I gave him, which was unresponded to, even after that, I waited even longer than that, recognizing that I was dealing with someone who was acting as their own attorney. And only when essentially it seemed that I wasn't getting anywhere at all is when I filed this motion.
Sure. Well, folks, I now have that it's 11:35. We've heard nothing from the plaintiff in this case. It's been set, noticed for the motion to compel, and informed Mr. Thomas that the case could be dismissed if he failed to appear. He has failed to appear, so this case will stand dismissed.
Is the court going to enter the order?
Yes, we'll take care of that.
And is that a dismissal with prejudice or without?
Well, it's going to be without prejudice. There's not, I don't know that there's anything that I can really, I guess if I found it willful, which I did say if he failed to appear, I know in the notice that we might, but I am hesitant. I will take a look at the record and decide whether it'll be with or without prejudice.
Sure.
Good.
Okay.
All right.
Ms. Walker, I am ordering takedown. Do you have my contact information?
I don't even have what you said when the judge said he was waiting on the
I am
person.
sorry. I did not know you were asking for take. Do you want takedown of all this, Ms. Koenig?
Can I have it just in the event that something comes up later?
Then we need to go back through and go through the whole thing, so.
I apologize, Your Honor.
Go ahead. No, I didn't give you a chance to, I made an assumption. I should have made.
No, I'm sorry, Judge, when you say you was waiting, normally we'll wait, so
I know,
I didn't know.
that's not your fault. It's mine.
sorry, Judge.
On this one, it's totally my fault. Go
Okay.
ahead, Ms. Gannick. You may start over.
Sure. This is a case in which the plaintiff initially had counsel and then his counsel withdrew and he was proceeding pro se. We served discovery. Well, we first wrote a letter to plaintiff about the outstanding discovery. Then we followed that up with a formal discovery request and formal discovery that was served upon him. Then having no response to it, we sent a Rule 6.4 letter reminding him of his duty to do so and respond. He did not respond to that letter. Thereafter, we waited additional time, recognizing that he was proceeding pro se before filing this motion. On the Friday before Memorial Day, we were contacted by Mr. Thomas's brother by email, indicating that he wanted to know what essentially we were seeking. It was not Mr. Thomas, but it was his brother. We provided Mr. Thomas's brother with a discovery request, with a motion to compel, including the discovery request being sought. His response was essentially that he would get it to us as quickly as he could. This hearing has been set for a while. We checked our emails religiously from Friday to today, looking to see if there was going to be any response other than that from Mr. Thomas himself, the plaintiff. We have had none. No other response was given by Mr. Thomas's brother. And Mr. Thomas and his brother, neither one of them have appeared on the Zoom hearing, and the court set this for 11:30, and it is now 11:38. And we would therefore request that this court do what the Rule 9 and hearing notice says. In other words, deem Mr. Thomas's failure to respond to discovery as being willful and issue an order striking Mr. Thomas's complaint and dismissing this case for want of prosecution. We would ask that it be dismissed with prejudice so that this matter can be closed.
Okay. And I will dismiss the case. I'll take under advisement whether this will be with or without prejudice, and that'll be included in the dismissal.
We thank the court.
All right.